Want to avoid problems in your next real estate deal? In this video, we're going to look at a recent article from the Toronto Star, where real estate lawyer Bob Aaron lists the top 10 issues that can lead to disappointment, unnecessary expense, and even litigation in real estate agreements. I'll read through the author's 10 points, and then I'll chime in with my own 2 cents. And just a quick note, as the author points out in the article, these issues are listed in no particular order. My name is Jason Bondy-Sawyer. I've been a realtor in Toronto since 2006, and I make educational videos like this one here to help buyers and sellers navigate the Toronto real estate market. If you find this video valuable, please go ahead and hit that like button and subscribe to the channel so that you don't miss any of our videos in the future. Okay, let's get into it. Issue number 1, the wrong unit. The author writes, I frequently see residential purchase offers where the wrong condominium unit is bought and sold. In many condominium buildings, the numbers on unit doors do not correspond with the registered unit and level number. For example, Suite 1407 may be registered as Level 13, Unit 8. Buyers should always insist on proof of the registered numbers at the time the offer is signed and not after the status certificate is delivered. So this is true. The legal description of the unit is sometimes different than the actual address. And the same holds true for the parking spot and the locker as well. Now there's a spot in every MLS listing for the listing agent to put the legal description of the unit, parking, and the locker. But you can't just assume that they've put the correct information in there. This info is included in the status certificate, but the status certificate is not always available at the time that an offer is made. So what your realtor should be doing is checking land registry because the information can be found there. Issue number 2, status certificate. Another common error is buying a condominium unit without a condition on reviewing the status certificate. Not reviewing a current dated status certificate can be both risky and expensive. So having a lawyer review the status certificate is crucial when you're buying a condominium. We typically include a condition in our offers that gives our buyer's lawyer 2 to 3 days to review the status certificate and then discuss their findings with the buyer before the buyer decides whether or not to go ahead with the transaction. Now, in the case where there's a scheduled offer date, the listing agent will typically have that status certificate available ahead of time. So we can still have our client's lawyer review it, but we do that prior to making the offer so that the offer doesn't need that condition in it. It can be a cleaner offer and more attractive to the sellers. Issue number 3, vacant home tax. If the owner of a Toronto home or condominium unit has not filed a vacant home tax declaration, the buyer could be subject to a penalty of 3% of the assessed value. A surprising percentage of offers that I see are missing a requirement for the seller to provide proof that the declaration has been filed. So if you watch the recent video I did on the Toronto vacant home tax, you know that I touched briefly there on what happens when there's a change of ownership on a property and the fact that a buyer and seller need to be clear about whether or not the occupancy status has been declared and what can happen if it hasn't. So yes, you definitely want to be sure that there is a clause in the agreement of purchase and sale that addresses this so that there are no issues on closing or after closing for the buyer. Issue number 4, commercial HST. Another error that occurs far too often is on agreements for a commercial property, where HST is intended to be in addition to the purchase price, being written on a residential form, where HST is included in the price. So I'm not a commercial realtor, so I can't really speak to this, but I can tell you that in a residential agreement of purchase and sale, yes, there is a section where we have to identify whether or not HST is included in or in addition to the purchase price. And that, of course, is a very important detail that should not be missed. Issue number 5, wrong forms. I have also seen agreements for cooperative or co-ownership units signed on a condominium form. This is looking for trouble. So that's right. And beyond that, there are some townhouse properties that are not condos, they're freehold properties, but they are tied to an interest in some amenities that are managed by a condo corporation. So things like parking lots, roads, sidewalks, etc. Offers on these properties need to be done on an entirely different form. So yes, as the author points out, you want to make sure that you're using the correct forms to avoid problems at closing. Issue number 6, furnaces, etc. Sellers need to be careful about whether their furnace, AC unit, and hot water tank are owned or rented. Too many sellers have inadvertently listed them as being included in the purchase price and wound up having to buy out the lease. Issue number 7, land survey. The most important document in any freehold transaction is a land survey, whether current or historical. Many legacy surveys are accessible online at protectyourboundaries.ca. If they are available, surveys should always be made part of the transaction. Issue number 8, closing date. Too often, closing dates are set for weekends or holidays when banks and the land registration system are closed, like Family Day this year, which is February 17th. Closing at month end is also risky due to bank delays in wiring funds. Check your calendar before signing. So we always double check that the closing is not a weekend or a holiday. And in fact, we also try to avoid Fridays as well. The reason being, let's say an issue pops up at 4 p.m. on a Friday, the next business day is not until the following Monday. So if you have movers booked and you planned on moving that weekend, this is really going to complicate your plans. Issue number 9, buying an estate property. Buying property from the estate of a deceased person, this requires a sophisticated postponement clause providing for the possibility of a delay if the estate trustees do not receive probate from the estate's court in time for the anticipated closing. Some courts are backed up as much as 9 months or more in processing probate applications. So ideally, the property doesn't even go on the market until the estate trustees have already received probate. Of course, that's not always the case. Now, it's not unusual for a property to sell while the probate process is still happening, but it just means that there's a clause that needs to be included that gives the seller the ability to amend and extend that closing date if needed. So as a buyer, you need to talk that through with your realtor, your mortgage broker, and your lawyer so that you know what that is going to look like. And then of course, there's the complication of trying to sell your current home and have the closing date of that line up with what is potentially a floating closing date on the estate property that you bought. Issue number 10, cottage and waterfront properties. Offers for cottage and waterfront properties require special clauses dealing with issues like building permits, septic permits, registered road access, shore road allowances, clean bacteriological tests for water quality, well drillers certificates for water quantity, fireplace inspections, building permits, and boat houses and docks. So I don't deal with cottages. We have specialists in our network that do deal with those. And yeah, if you're buying a waterfront or cottage property, you definitely want to be working with a specialist. Okay, there you have it. 10 issues in Toronto real estate deals gone wrong. Over here are a couple of other videos I think you want to take a look at. Over here is a link to subscribe to this channel. That's it for now, and I'll see you next time.